guess, let people in, right?
Yeah, and just before we start, make sure we let everyone know that the session is being recorded.
Okay. All right.
All right, welcome everyone. We will get started in just a few minutes. Audrey, can you let me know when we are good to start on your side? Cool. All right, as more folks continue to join us, I'm just going to get us started here. A little housekeeping for our event today. So welcome everyone to Executive Orders and DEI Actions to Take, hosted by us, the Mariana Strategies team. My name is Michaela Collins, and I'm our program associate here. Our hosts today, our fellow hosts, are Audrey Buffet, our CEO, and consultant Dr. Swati Srivastava. So before we get started, we want to note that this webinar is being recorded today. And so everyone who has registered, everyone who is attending today, will receive a link to the recording after today's session. And also thank you to everyone who has sent us questions in advance of today's event. We have incorporated those responses into the information that we'll be delivering. So thank you for sending those in. If you have any additional questions as we continue our discussion, we invite you to put those questions into the chat. We'll be answering those at the end of the presentation, so we'll save a little time for those questions at the end. So as more folks are coming in, we want to talk about what we're going to talk about today. So when it comes to our goal today, it's to give you a high-level overview of the recent executive orders that are impacting employers on civil rights and efforts to ensure inclusion for all at work, especially for transgender and gender non-conforming workers. So now is the time for every private employer to evaluate their commitment to DEI and civil rights in the workplace. This means reviewing to ensure that you provide equal access to opportunities and skills development. It means ensuring that employers do not give special advantages to one person or group over another, and that it also involves initiatives that foster inclusive workplace cultures. So our CEO, Audrey Buffet, will talk about what the recent executive orders say and which employers are impacted by them. Dr. Swati Srivastava will talk about communication strategies to support your team and ensure you don't lose ground on inclusive practices. And she will also talk about guidance for complying with these orders, the guardrails for what actions are legally risky, what actions will likely engender scrutiny, as well as where confusion remains. At the end, if you have just joined us, we will open the discussion for questions, and we invite you to put them in the chat as we go along today. And then we'll talk about how to continue important workplace culture work that is consistent with your organization's values and mission. So as we continue on, I'll turn it over to my colleague Swati to start us off.
Thank you so much, Michaela. So we think that some background on our approach is important to understanding why we are talking about the executive orders today. We at Mariana Strategies are a multidisciplinary team with decades of experience in law, nonprofit management, applied social psychology, and program.
I was on that. No. It was just that webinar that I was taking, you know, the DEI.
If everyone could please mute themselves, we'd really appreciate it. Thank you. We use our expertise to design and deliver tailored, evidence-based workshop culture solutions for clients. We're a small but mighty team, and when you partner with us, you get us from start to finish. Now, our clients are typically mission-driven teams in government, nonprofit, and international organizations. Our experience includes working with complex, high-pressure cultural challenges. Now, before I pass to Audrey to walk us through the specifics of the executive orders, we don't want to take for granted that not everyone knows the history of workplace DEI initiatives, as well as the challenges that have been faced in the past. This work emerged from civil rights era's laws in the 1960s and 70s, and originally was focused on affirmative action. Pushback was there right from the start, with critics arguing that this practice was reverse discrimination. It wasn't until the 1980s and 90s that companies actually realized diverse teams improve innovation, they improve market reach. But again, critics claimed that increasing representation was just a checkbox exercise. And where was the data to show impact? Now, by the 2000s, the focus of this work shifted to inclusion and unconscious bias training. But when studies showed that unconscious bias training had limited impact on behavior change, critics seized the opportunity to call all DEI efforts ineffective. And that brings us to this post-2020 era, which we are all familiar with, where workplace DEI efforts have surged but faced almost immediate pushback, with critics arguing that this work is more PR-driven than anything else, and that it's divisive or ineffective. Now, the point is that we've been here before. Labels might change, but the work doesn't. Today, we're going to walk you through those executive orders, what they mean and what they don't, the law, and most importantly, how we can shift, not end, our work towards data-driven, culture-focused strategies that emphasize workplace belonging, fairness, and collaboration, rather than politically charged DEI language. I'm going to pass over to Audrey to start talking about why we're here.
Thank you, Swati. And as I get started, I just want to note that even though I'll be talking about the executive orders, this webinar is for informational purposes only. This is not legal advice, and regarding your specific organization and its needs, compliance-specific guidance will be crucial for you to have. With that said, I want to talk about how we got here and what we're navigating right now. So momentum has been building to suffocate DEI efforts, and especially equity-related efforts. If we're looking at the period from the middle of the last Trump administration to now, there have been efforts to create opportunities for individuals who've been historically underrepresented in places where opportunity abounds, right? In education, this meant affirmative action in college admissions. In the Students for Fair Admissions case, the United States Supreme Court said that the goal of achieving a diverse student body cannot justify using race as a plus factor in college admissions, effectively ending affirmative action. That's the educational context. In the workplace, lawsuits were brought against law firms for fellowships that were available to individuals from backgrounds that have been historically underrepresented in the law. Eligibility for those fellowships were usually limited to people of color. The litigation around that forced the firms to change the application criteria to be race neutral. In both of the lawsuits noted on this slide, the funding and driving force behind it was Edward Bloom and his organizations. So as a crude summary, one that misses some distinctions, but it's true nonetheless. These lawsuits use the law to ensure that Black people do not get an advantage that white people do not have access to. Some of the strategies in these lawsuits that were used over the last few years are reflected in these executive orders. So you can anticipate similarities. Let's talk about what an executive order can do and can't do and the context in which it exists. So at the federal level, you know, we have 3 branches of government: Congress, which makes the law; the executive branch, which carries it out and enforces the law; and the courts, which interprets the laws. I'm telling you this because the president can issue an executive order telling federal agencies how to carry out the law and what policy priorities are. An executive order cannot override federal laws, cannot override the Constitution. This is why, for instance, there's currently an injunction against the executive order challenging birthright citizenship, because the order is inconsistent with the Constitution. This context helps us to understand who is affected by these orders and how these orders work. So we're looking at 3 different groups here. The maximum direct impact is obviously on federal agencies and federal employees, because that is the nature of the executive branch and its power. As of last week, all DEI offices and roles were eliminated in federal agencies, and federal employees in DEI positions were placed on paid leave. It's important to note that in none of these orders is DEI defined. I expect a challenge based on the Administrative Procedures Act, because this is incredibly unclear. But for now, there is some discretion in how this is being implemented. The next category of entities impacted by this order are federal contractors and grant recipients. When we're looking at what this means, equity-related grants, contracts, programs have been terminated. There is a new requirement to certify compliance with federal anti-discrimination laws, and we're going to see increased enforcement and compliance reviews. That's for that middle category. This third category, control via litigation and risk aversion, this impact is on private businesses, foundations, and nonprofits. There's going to be potential for investigations into DEI programs, and the focus is on large organizations, specifically called out in the executive orders. Today, we're going to be talking about these particular orders, these 3. And as you've seen, there are many that have been issued in the last few weeks. There are related orders and memos on implementation, but we want to start here so that you have the basics. The first one that we'll be talking about is the federal DEI shutdown order. Then we'll talk about the private sector freeze order. And finally, while this does not specifically comment on DEI, the anti-trans order will have implications for any organization that is committed to diversity. So I'm going to talk briefly about each of these and then discuss the implications for contractors, grantees, and the private sector. The federal DEI shutdown order ended federal DEI programs and eliminated DEI positions. what it does is set in motion, additionally, a plan to revise federal employment practices to prioritize individual merit and performance and explicitly exclude DEIA considerations. Even in this federal shutdown order, there are implications for non-federal employees. The first is that federal agency heads are required to share with the Office of Management and Budget a list of federal contractors and grantees that have been involved in DEIA activities since January 20th, 2021. That's the first day of the Biden administration. The order directs the termination of equity-related grants or contracts and directs the termination of any and all DEI or DEIA performance requirements for employees, contractors, or grantees. That's the first order. The second order that we're looking at is the private sector freeze. And what this order does is seeks to use available leverage to disincentivize private sector organizations, federal contractors, federal grantees, as much as possible from engaging in undefined DEI work. For contractors and grantees, these awards will have language that requires that the awardee certify that it does not operate any programs promoting DEI that violates any applicable federal anti-discrimination laws. I'm going to talk about that more a few slides in, but I'm flagging that for you because it's truly at the heart of what this order is capable of doing. The requirement does not add a new obligation. What it does is that it makes it possible for individuals to bring suits, essentially as whistleblowers or key TAM relators, to use the False Claims Act to enforce non-discrimination requirements. The order also drops the affirmative action requirements for federal contracts and grants. No longer will contractors have to take positive steps to ensure that individuals have equal opportunity in employment without regard to protected categories, race, color, religion, sex, national origin. When it comes to private sector companies that do not have federal contracts or grant obligations, there is a chilling attempt. The president directed agency heads to submit to the White House strategic enforcement plans to be used alongside the Department of Justice to recommend enforcing federal civil rights law to encourage the end of illegal discrimination and preferences, including DEI. It specifically notes that each agency is instructed to include up to 9 large companies or nonprofits for potential civil compliance investigations, as well as litigation that would be appropriate for federal lawsuits. One thing I'd like to note about this order is that an executive order cannot ban DEI, and federal courts have repeatedly held that private employers have a First Amendment right to promote DEIA and encourage people to embrace the values behind it. This came up in a Florida lawsuit when Governor DeSantis tried to ban DEIA in the private sector, and the court noted that while the state had called the measure an anti-discrimination law, it actually targeted, quote, ideas designated as offensive and suppressed speech based on its content. The government, the court concluded, said that it cannot penalize employers who promote DEIA just because lawmakers believe the expression of these ideas is inherently discriminatory. Let's talk about the third order. This is the anti-trans executive order. And in this one, we do get some definitions. Let's talk about a few summary items here. What this order does is erase gender in federal agencies. Federal agencies must replace the term gender with sex in official documents. When it comes to government-issued identification, passports and other IDs must reflect biological sex assigned at birth. Federal agencies have to reverse policies around single-sex spaces, reversing policies that allow gender identity-based access to bathrooms and other single-sex spaces. And we have new enforcement priorities. The Attorney General, the United States Equal Employment Opportunity Commission, which enforces our anti-discrimination laws, and the Department of Labor must prioritize investigation and litigation, enforcing rights based on biological sex distinctions. What we're seeing here is that we're rolling back guidance, including the 2024 EEOC workplace harassment rules that incorporated protections for LGBTQ+ workers. Significant area of challenge we're going to see is going to be around the Supreme Court's holding in Bostock versus Clayton County. In that case, the protections against discrimination in the workplace based on sex were extended to include gender identity and sexual orientation. This order instructs federal agencies to prevent the expansion of this holding. One thing I want to point out for the contractors and grantees here is this language in the box on the right. Each agency shall assess grant conditions and grantee preferences and ensure that grant funds do not promote gender ideology. I think we're going to see challenges to this, but it is intended to ensure that trans people, gender non-conforming people, are erased from services to which they are entitled. This order is one of a number of orders and directives that aim to prevent gender non-conforming folks, transgender folks, from seeking healthcare, educational support, social services, and other protections. So with these three orders and those brief summaries, I want to talk a little bit about what organizations are able to do when it comes to fulfilling civil rights obligations and doing right by the people you work with. In the two DEI specific orders, the president goes as far as an executive order can to direct private non-governmental efforts. And what he does there is remind organizations of the obligation to avoid discrimination on the basis of protected categories. Under Title VII of the Civil Rights Act of 1964, employers, including the federal government, the largest employer in the United States, are prohibited from engaging in discrimination in workplace actions against people on the basis of protected categories: race, religion, national origin, color, sex, including gender and sexual orientation. What does this look like in practice? If you have two candidates for a position with similar backgrounds, experience, expertise, education, and you choose the white man because of his race and his sex, that would be illegal discrimination. The kinds of opportunities that are encompassed here: hiring, firing, how much you get paid, what assignments you get, classification, promotions, who gets laid off, who gets recalled, how you recruit, the use of facilities, opportunities like fellowships, training programs. Okay. Under Title VII, employers also cannot allow harassment because of any of these categories, or making employment decisions based on stereotypes or assumptions about a person's abilities, traits, or performance. For instance, calling someone a DEI hire. Title VII makes it unlawful to use policies that seem neutral on their face, but have the effect of discrimination. In practice, we are looking at these examples on the right. Things that should be avoided. Hiring quotas based on any protected category. Setting aside opportunities for a certain percentage of people on the basis of any protected categories. Like the example I gave earlier about a tiebreaker in decision-making and choosing to give an opportunity to someone on the basis of their race or their sex. Going back to the example of law firms and the fellowships, making those specific opportunities available only to people who belong to a protected category. And compensation tied to reaching a goal of diversity in hiring or promotion. All of those should be avoided. Okay. At a high level, there are some risks, obviously, that exist here and that we want you to be aware of. Making sure that you have the guidance that you need is very important. And clearly the administration has burst out of the gate with these efforts and is shooting first and asking questions later. When it comes to contractors and grantees at the federal level, these orders indicate that no federal money will go toward illegal DEI work. It couldn't go to illegal DEI work before, but now contracts will have terms requiring certification that the awardee does not operate any programs that promote DEI that violates any applicable federal anti-discrimination law. And there's the risk of private litigation under the False Claims Act. That's that whistleblower, key tam relator that I mentioned earlier. When it comes to private entities, there is less that an executive order can do to impact your business directly, but there is language aimed for maximum chilling effect on the corporate and charitable drivers of culture in the United States, directing agencies to keep an eye out and list up to 9 organizations that would be the most egregious and discriminatory practitioners. Specifically, the order mentions publicly traded corporations, large nonprofits, foundations with assets of $500 million or more, state and local bar and medical associations, and institutions of higher learning with endowments of over $1 billion. This is aimed to drive culture from the most powerful institutions down. I want to talk briefly about what overcompensation looks like in compliance with these orders. DEI is not defined anywhere here. And that ambiguity works to the administration's advantage, because when leaders don't know what the government and the court's view will be of the programs that are lawful, they are going to be more conservative. It's very important to review your DEI efforts closely and ensure that you're not engaging in actions that would violate anti-discrimination law at the federal level, and that you give your teams the skills that they need to follow these directions. For many people, they're going to experience whiplash. If DEI has an organization's full-throated support on Monday, and then it's removed from your website on Tuesday. Getting support is crucial on communications, programming, and training so that you can thread that needle. When it comes to sex and gender and the anti-trans order, there is that specific guidance that funds cannot be used to promote gender ideology. And this is truly set up for a fight in light of the protections of Bostock versus Clayton County. An important piece to note is that states and municipalities, in many instances, require protection against discrimination on the basis of gender. You likely have terms in your employee handbook noting what protections exist. Don't let your people down. I mentioned earlier that executive orders can set policies and priorities of the executive branch. And we see in the anti-trans order that the EEOC will be prioritizing investigation and litigation that enforce rights based on biological sex distinctions. For instance, we anticipate seeing that somebody being asked to use pronouns would be a violation of their right to enforce biological sex distinctions. That in turn would be inconsistent with the protections in Bostock versus Clayton County. And certainly, I think that this will come at the expense of investigations into transphobic harassment in the workplace. Obviously, there is much, much more that we could talk about when it comes to these orders. What I want to do now is turn it over to my colleague, Swati, to talk about what efforts we should be leaning into right now.
Thanks so much, Audrey. So when we talk about efforts to lean into, as Audrey mentioned, there's a lot of ambiguity around the definition of DEI. And the good news is that a lot of the efforts that really are focused on improving workplace culture really do tie in to organizational goals. So we really want to go over some of those key initiatives that actually help to reduce legal risk and are absolutely inclusive culture building efforts. Now, first and foremost is de-biasing your workplace systems and focusing on data. So what does that look like? That's implementing structured interviewing and hiring processes with transparent criteria. It's a standardization, right? Removing bias in resume screening, promotions, mentorship access, and work assignments. It also means things like expanding candidate pools, increasing pay transparency. Another part of this is the ability to use data effectively, which can help solidify your business case for this work. This includes everything from systems audits to measuring belonging and fairness through employee surveys, and most importantly, monitoring the impact of skills building trainings. So an example of this might be comparing pre and post intervention data to see what's working, as well as how your workforce plans to execute real change as a result of a training. Now at Mariana Strategies, we ensure that data is embedded in every one of our service offerings, because it's the data that really shows how to not only measure the change, but focus on the things that are working. Another key effort here is using universal inclusion frameworks. That means a focus on emotional intelligence, psychological safety, conflict resolution, growth mindset. These are skills that benefit all employees. And finally, inclusive leadership. Encouraging leaders to lead in these skills building efforts and to tie these soft skill developments into performance evaluations and promotions. Now, there are a number of other SAFE programs that don't necessarily fall neatly into one of these categories, but the things that you want to look at are, employee benefits, work-life policies, flex work, parental leave, fair distribution, fair work distribution to prevent office housework from disproportionately impacting certain groups. Supporting identities beyond race and gender, looking at things like age and disability. Community partnerships, philanthropy, and mandatory anti-bias training for decision makers throughout your organization. So doing the work is most important, but how we communicate about it also matters. And what we suggest here, what the key really is that human-centered communication, making the discussions less about politics, more about people, and encouraging dialogue rather than division. So the first part of that is we listen, right? Lead with psychological safety. Creating safe spaces for questions, concerns, whether that's through listening sessions, continuing confidential surveys, and encouraging storytelling, right? Personal stories resonate much more than facts or stats alone. Next, you want to be able to reframe the narrative. You commit to this work, but shift the focus to belonging and performance. Still using inclusive language, but around workplace excellence, fairness, and team cohesion. All the while tying these into your organizational values and goals, driving innovation, driving collaboration, retention. And finally, we adapt. Sometimes we need different messages for different audiences. If your executives need a solid business case, focusing on data, right? Inclusive teams have 35% better performance. If you're talking to skeptics, focusing on fairness and respect, because we all work better when we feel respected. And for your advocates and your allies, equipping them with persuasive tools and bridge building strategies so at this crucial time they feel supported. Now, if you think that this is a lot, it's because it is. There is a lot to review and to discuss, and each organization has its own specific needs. So we encourage you to review your DEI efforts closely to ensure that A, you are not engaging in actions that would violate any anti-discrimination laws at the federal level, and B, that you're giving your teams the skills they need to navigate these directives. I'm going to turn it over to my colleague, Michaela, to talk us through some additional resources that we have for you.
So at the top of this call, we mentioned that everyone who has attended today and has registered will receive a recording of this webinar to go back to. We know we gave you a bunch of information, so we want you to be able to review it at any time. We will also be sharing a reference document that has informed everything that we've shared with you, including direct links to the executive orders that have been mentioned and the resources for understanding how we got here and what you can do to take action. And so everyone will receive these resources and this webinar recording after today's call. But right now, we want to open it up to your questions that you have for us. If you have any questions, feel free to share them in the chat or raise your hand and we will get to your questions. Flav asks, is there a crucial difference between affirmative action and DEI? That is a great question, and I will turn it back to Audrey and Swati to help us answer that question.
That's a great question. And hi, Flav, it's great to see you again. There is a crucial difference between affirmative action and DEI. DEI as a construct doesn't have a legal definition. It can be a set of policies that are made within an organization, separate and apart from HR policies, learning and development, that's a component. But the affirmative action element that I mentioned earlier has to do with rebalancing efforts. And those structures are particular to policies in a given organization. That's going to be very particular. You might have seen yesterday that Google is pulling back on its efforts to reach diversity goals. Those would be distinct from affirmative action goals that are set and programmed for a specific company to meet specific targets when it comes to seeing that the people working in a given industry better represent the communities they seek to serve. Right now, that distinction remains.
Audrey, the only thing I would add to that is that affirmative action was possibly the original piece of the puzzle with regards to DEI work. And now DEI work has expanded to mean so much more. We're talking about, management skills building. We're talking about culture. We're talking about a lot more than just rebalancing of opportunities in the form of hiring and promotions, et cetera. So when you ask, is there a difference? There's so much more to DEI, and again, this goes back to the problematic issue here that DEI in these executive orders has not been defined. So that creates a level of confusion for a lot of folks about what they can and cannot continue to work on.
Another question that we've gotten from Nicole is, what about externally offered programming for women? For example, leadership programs. How are they affected?
Great question. If we are using the law firm cases as examples, then an argument could be made that yes, limiting access to opportunities on the basis of a protected category would cause some challenges. At the same time, if the opportunity to belong to a certain group isn't a workplace opportunity, then you can still belong to a women's only group. But if you make it something that is an opportunity in the workplace, that is likely to be challenged. What some of the law firms have done to make their way around this eligibility issue is to make the criteria one that is contingent on supporting goals of diversity or overcoming adversity, as an example. I saw Hadil's hand up. I want to make sure that we don't miss Hadil.
Thanks, Audrey. It was a very similar question to Nicole's about leadership programs that are targeted towards a certain group, and a little bit of the difference between the risk for if the institution is still choosing to carry on the program, is there a risk, or is it just that we won't get government employees, for example, to take the program, to enroll in the program? And will all government agencies interpret the executive order in the same way? Because we've seen that some government agencies are still enrolling their staff in these leadership programs, and some other government agencies have said, per executive order X, we cannot be part of this program. So I'm curious if that is an interpretation piece, and then the difference between that and the organization still choosing to move forward with that, and what potential risk exists.
That's a really good question, and I want to frame it in the context of what benefit is being given to an employee. And when a benefit is available only to members of a protected category, that's likely to be challenged.
We have a question from Maggie Ludlow. I'll let you take that, Audrey. And then I'll take the follow-up question from Karen Truman. Maggie's question is, just to clarify, is it now illegal to enforce the use of correct pronouns?
No, it would not. And again, this is not legal advice, but that is a free speech question. And using the pronouns that a person has is protected speech. That would be important to note. What is limited now will be federal agencies using gender as a category at all.
Thank you. Karen's question is, we are a small private organization and currently require employees to take DEI training as part of compliance training each year. Should we remove this requirement? So first and foremost, I would say, make sure that the content of that training is legally compliant with what was discussed. You're a small private organization, so there is a lot more freedom to what you are able to include in your training. But again, when we talk about it, we don't have to use the label DEI training. These are typically cultural competence trainings. Typically, you are building inclusion. You are helping your staff, your leaders build skills to improve your workplace culture. So again, take a close look at the content, but given this is something that we do as well, a service that we provide, typical contents of DEI trainings are aligned with cultural competence. Dominic's question here is, how do organizations begin to rework their awarded federal grant proposals to protect them from discrimination complaints when executing grant objectives with a focus on supporting historically marginalized groups in our community?
I think that's a really important question. And as with all of these, we can give broad brushstroke thoughts, but really specific elements will need to be worked out in detail. But what I would say is, when it comes to implementing your grant objectives, this connects back to the promise and the goals of civil rights legislation. And the attack on civil rights that we're seeing as part of these orders need to be factored in, but following the guidance of Title VII to avoid discrimination on the basis of protected categories is going to be a strong approach.
Kate has a question on, based on the orders, is it a fair assumption that culturally specific service funding will be impacted, both with stop work orders for current awards and future funding?
Great question. We certainly see that any awards that had DEI as an element, you would expect it to be shut down immediately. And there will be questions around the Federal Tort Claims Act and contract enforcement here. I think it's an exception to, I think it's something that you should look at closely if there are DEI elements in federal contracts that you have currently. But looking at the component, for instance, that promoting gender ideology is an issue, looking at culturally specific service funding, I think that there will be a hand on the scale to ensure that favored contractors will receive contracts based on ideology, and disfavored contractors will not. I would anticipate that to happen. And I see this question about whether supplier diversity initiatives will end. One of the orders notes that agencies are going to be asked to provide reports indicating the costs of DEI initiatives, including set-asides. While the Small Business Administration and the elements for Hub Zone and women-owned small businesses are still intact, their future is unclear.
There's also a question on what are the potential impacts on nonprofits who do not receive USG funding, and what's the trickle-down effect of those policies, both right now and where we're potentially heading.
For entities that do not receive federal funds, these executive orders do not have direct application. If you look at the elements around what private entities are going to experience, there is an attempt to move the culture away from DEI. I would suggest that this is an attempt to move the culture, but I would focus on your people and your values. And I think that will be the most important guiding principle for how you execute changes on these initiatives.
Does anyone else have additional questions? A few minutes left. If not, we know that this is a huge amount of information to process, and it cannot be tackled in 1 hour. So we would like to remind you that we are here to help provide the tailored guidance and support you need for your organization. You are welcome to reach out to us, to Audrey, our legal expert and CEO, and to Swati, our organizational psychologist. You can reach out to us at any time. And we will also include our contact information so that you have access to the guidance and support you need for parsing out what navigating these challenges look like. So Audrey or Swati, do you have anything to add before we let up?
Nope, that was perfect. Thank you all so much.
I'm happy to stick around and answer questions.
Mm-hmm.